the fluorescent hum of a grocery store. It's a soundscape of the mundane, the everyday. Shopping carts rattle, a distant intercom pages an employee, and the soft rustle of plastic bags fills the air. It is in this temple of the ordinary that we begin our story, a story that starts with a fall. But this was not a simple accident. This was a performance. The stage was aisle 7, canned goods. The actor, a woman we will refer to as Ms. A, and the audience, the silent, unblinking eye of a CCTV camera. What it recorded on November 12, 2023 at 2:17 p.m. would become the centerpiece of a legal battle, a piece of evidence so clear, so damning, that it would force the truth to explode in a quiet courtroom months later. This is not just about a slip. This is about a lie, meticulously constructed and then systematically dismantled. This is about the people who believe they can manipulate a system built on good faith. The hereges, quem, ideologicamente, atacamos, who raise costs for everyone. And it is about the cold, hard power of evidence. For 45 seconds, we watch her. She moves without urgency, her hand trailing along the shelves of soup and vegetables. She is not a woman in a hurry, nor is she a woman displaying any sign of physical distress. She pauses, picks up a can, examines its label, and places it back. Then, the moment. She glances to her left, then to her right. The aisle is clear. In one fluid, controlled motion, she begins to lower herself to the floor. There is no stumble, no misstep, no wet spot on the linoleum to blame. It is a deliberate descent, a slow, careful sinking against the metal shelf. She ensures her back is supported, her head resting against the cans. And then, she becomes still. The performance has begun. This is our entry point into the world of CCTV exposes, where the truth is often hiding in plain sight, waiting for someone to press play. This single act of deception is a poison in the well. It casts a shadow of doubt on every legitimate claim. It forces insurance premiums to climb, a hidden tax on honesty. It wastes thousands of hours of investigative resources and clogs our legal systems. Every dollar paid out on a fraudulent claim is a dollar taken from the pool, meant for the truly injured, for the honest payer who depends on the system functioning as intended. The lie told in aisle 7 is an attack on that very foundation. It is an ideological stance that personal gain trumps collective responsibility, and it is a stance we will dismantle, piece by piece, with the very evidence the perpetrator provided. This is how a lie unravels. If you value truth over fraud, subscribe. Protect the system for the honest payer. The scene is set. The claim is filed. But before the ink was even dry on the paperwork that detailed a debilitating back injury and a life of pain, the counter-narrative was already recorded, locked in a digital file, waiting for its day in court. The journey from claim to conviction starts with a single, quiet moment of deception under the bright, unforgiving lights of a grocery store. What happens next is a dance between a fabricated reality and the immutable truth of the CCTV receipts. The clock is ticking. The investigation is about to begin. The fall was only the opening act. The real machinery of the claim began to spin into motion 72 hours later, on November 15th, when the official paperwork landed on the desk of a claims adjuster. This is where the story written by Ms. A diverges completely from the one recorded by the camera. The fraud files were now officially open. The narrative constructed in these documents was one of sudden, acute trauma. It described a horrific slip on a mysterious, unidentifiable liquid, a violent fall onto the hard floor, and an immediate, searing pain in the lower back that radiated down the leg. The claim was a masterpiece of manufactured suffering, detailing an inability to work, to perform household chores, or even to sleep through the night without agonizing discomfort. It was a portrait of a life brought to a screeching halt by the negligence of a grocery store. On paper, it was a solid, compensable claim. This paper trail is the shield that fraudsters hide behind. It transforms a subjective feeling into an objective fact in a legal file. Doctors' reports, initial though they were, echoed the claimant's complaints, noting patient reports severe pain upon palpation and limited range of motion. The system, designed to help the genuinely injured, began to mobilize around this fictional reality. Physical therapy was authorized. Medications were prescribed. The financial clock started ticking, tallying up lost wages and medical expenses. The sheer weight of the documentation creates an inertia of belief. It's easier to pay a questionable claim than to fight it. A calculus that fraudsters understand and exploit with chilling precision. This is the battleground. A stack of papers asserting one truth against a silent digital file containing another. But a seasoned investigator's first question, the mantra that separates truth from fiction, is simple. Show me the footage. The claim adjuster, trained to spot inconsistencies, found them even in these early stages. The description of the fall was oddly vague on the cause, but incredibly specific about the effects. There were no witnesses mentioned who could corroborate the alleged liquid hazard. The timing, right before a weekend, was a classic red flag. This wasn't proof, but it was enough to trigger a deeper look. The request was formalized. Secure all surveillance footage from Fresh Fair Market for the date and time of the alleged incident. The paper reality was about to collide with a digital one. This phase of the investigation is a silent duel. The claimant, through their attorney, continues to build a mountain of subjective evidence. More doctor visits, more detailed accounts of their suffering, a deposition being prepared that would cement their story under oath. Meanwhile, the investigation team is moving in the opposite direction, seeking the objective, the immutable, the CCTV receipts. They are gathering the evidence that will form the foundation of the defense, the proof before hype. The two realities are on a collision course, and the impact point will be a conference room where an adjuster, an investigator, and a lawyer will press play on a video file and witness the first major crack in the claimant's elaborate facade. The staged fall was just the beginning. The unraveling was now underway. The conference room is silent, the air thick with anticipation. The only light comes from the large monitor on the wall. An investigator navigates a file directory and double-clicks on a file named IL 714 15 G1 to Thorn 1730. This is the moment of truth. This is where the paper claim meets its digital reckoning. The video begins to play. For the first minute, it's mundane. We see Ms. A enter the frame, her posture relaxed, her movements fluid as she browses the canned goods. There is no hint of a pre-existing injury, no cautious gait, no sign of the debilitating pain she would later describe. The adjuster watching makes a mental note. The body language doesn't match the claim. This is the quiet before the gavel drop. Then, the timestamp hits 14:17:02. The investigator, having previewed the footage, says softly, "Watch this." Everyone leans in. Miss A's head turns, a deliberate scan of her surroundings. Left, right. The aisle is clear. She is not looking for a product. She is ensuring there are no witnesses to what happens next. There is no slip, no trip, no loss of balance. Instead, she initiates a controlled, almost graceful descent. She bends her knees, lowers her body with clear muscle control, and carefully positions her back against the shelf before settling onto the floor. It is a performance, a pantomime of an accident. The CCTV receipts don't just capture an event, they capture intent. The silence in the room is broken by the adjuster letting out a low whistle. "It's a staged fall," he states. The words hang in the air, a definitive verdict reached in a private room long before the case ever sees a judge. This is the first major fracture in the claimant's narrative. The video evidence is so stark, so contradictory to the claim of a violent, accidental fall, that it transforms the case entirely. It is no longer about whether the store was negligent. It is about whether the claimant committed fraud. The proof before hype is now visually, undeniably established. Every subsequent piece of evidence will be viewed through the lens of this footage. The doctor's reports now seem gullible, based on fabricated symptoms. The claim of sudden, traumatic injury is rendered implausible by the clear, premeditated nature of the act. This is the power of objective evidence. It cuts through the noise of subjective complaints and legal posturing. It is the gavel drop that echoes through the rest of the investigation, setting an irreversible course towards a courtroom reckoning. But the investigation doesn't stop here. Identifying the staged fall is crucial, but it only disproves the mechanism of injury. The claimant's entire case is built on the effects of that fall, the alleged lifelong disability, the constant pain, the inability to lead a normal life. To dismantle that part of the story, the investigators need more. They need to prove that her life outside the doctor's office and the lawyer's depositions is fundamentally different from the one she describes under oath. The search for more evidence, for the CCTV receipts that will shatter her disability narrative, is already underway. The net is widening. The staged fall was the foundation of the lie, but the edifice of fraud was built upon the claimed disability. The fraud files detailed a life of limitation, an inability to work, to lift groceries, to play with children, to engage in any meaningful physical activity. This narrative of constant suffering was the engine of the financial claim, justifying thousands of dollars in lost wages and future medical care. To break the case wide open, the investigation had to move beyond the grocery store aisle and into the real world. The question was no longer, how did she fall, but how does she live? The answer came from an unexpected source: a public park, a sunny afternoon, and a separate, unrelated city camera system. This is where the second, and perhaps more damning set of CCTV receipts was discovered. The footage, dated November 20th, just over a week after the alleged debilitating injury, shows a completely different person from the one described in the medical reports. Ms. A is seen walking through a park with a friend, her stride long and confident, without a hint of a limp or the cautious, stiff movements one would expect from someone with a severe back injury. But the gavel drop moment comes a few minutes into the footage. A small child, perhaps 2 years old, runs towards her. Ms. A laughs, bends at the knees and waist with fluid ease, and scoops the child up. In one effortless motion, she lifts the child high and settles them onto her shoulders, the child's little hands gripping her hair for balance. She then continues walking, the picture of health and vitality. The act of lifting a child, a dynamic load requiring core stability and back strength, was a complete and utter repudiation of every symptom she had claimed. This is the power of proof before hype. While the staged fall video exposed the lie's origin, the park footage eviscerated its consequences. It provided irrefutable evidence that the disability was a fiction. This was no longer about a single moment of deception. It was about a sustained, ongoing fraud. The investigator who found this footage knew its value immediately. It was the silver bullet. It transformed the case from a "he said, she said" about a slippery floor into a demonstrable case of perjury and criminal fraud. The CCTV exposes not just the act, but the entire fraudulent persona. The contrast between the woman in the park and the woman described in the deposition transcript could not be more stark. It was a life of contradictions, captured in high definition. This external observation cemented the red flag indicators. It demonstrated premeditation and a conscious intent to deceive the system for financial gain. She wasn't just exaggerating an injury, she was inventing one entirely, and then living a life that proved the invention false. The existence of this footage allowed the legal team to build a narrative of their own for the upcoming deposition and hearing. They would let Ms. A commit to her story of suffering under oath, and then they would present this footage as the ultimate contradiction. The trap was set. The verdict reel was already being compiled, and its most devastating clip was not in a grocery store, but in a sun-dappled park. With the CCTV receipts from both the grocery store and the park securely in hand, the legal strategy shifted from defense to entrapment, not in the legal sense, but in a narrative one. The deposition scheduled for January 10th was no longer a fact-finding mission for the defense. It was an opportunity to let the claimant build her own cage, word by perjured word. The attorney for the insurance company entered that room with the calm certainty of someone who already knew the ending of the story. His role was not to confront, but to facilitate. He needed to get Ms. A to lock herself into the most extreme version of her fictional disability, making the subsequent revelation of the park footage all the more devastating. This is the quiet, methodical process that leads to a courtroom reckoning. The deposition began under a veil of normalcy. Under oath, Ms. A, guided by her own lawyer, detailed the accident. She spoke of the mysterious liquid, the violent fall, the life-altering pain. Then the defense attorney gently took over. His questions were soft, almost sympathetic, designed to elicit expansive answers. "Can you describe for me what a typical day is like for you now?" he asked. Ms. A, seemingly emboldened by the perceived sympathy, dove deep into her fabricated suffering. She described being largely bedridden, unable to cook for herself or clean her home. She spoke of the agony of bending over to pick up a remote control. She specifically mentioned, with a tremor in her voice, that she could no longer lift her young niece, a moment that she said broke her heart. Each statement was a nail in the coffin of her own credibility. The attorney simply nodded, taking notes, ensuring the court reporter captured every single damning word. This is the pivotal moment where a fraudster's confidence becomes their greatest weakness. Believing their lie to be secure, they embellish it, adding details they believe will make it more believable, but which actually create more points of failure when the truth emerges. The phrase, "proof before hype," was the guiding principle in that room. The attorney had the ultimate proof, but he allowed the hype to reach its peak. He needed the official transcript to contain the most extreme version of her claims, so that when the video evidence was presented, the contrast would be undeniable, the perjury incontrovertible. It was a masterclass in legal patience. He wasn't there to win an argument that day. He was there to create an unassailable record for the judge. The deposition concluded with Miss A reaffirming her entire story under the penalty of perjury. She left the room, likely believing she had secured her payout. What she didn't know was that she had just performed the final act of her own undoing. The attorney packed his notes, the fraud files now fattened with her sworn testimony. The next step was to formally file the counter evidence with the court, a motion that would include not only the grocery store staged fall, but also the park footage that directly contradicted her specific sworn claims about her inability to lift a child. The stage was now set for the final confrontation. The gavel drop in the deposition room was silent, but it was about to echo loudly in a hearing chamber. The hearing room carried a different weight from the deposition. This was no longer a private inquiry, but a venue for official judgment. The air was crisp, formal. On one side sat Ms. A and her attorney, their posture still projecting a facade of wronged innocence. On the other, the defense team, their demeanor not of aggression, but of quiet preparedness. They possessed the verdict reel before the verdict was even spoken. The judge entered, a figure of imposing calm, and the proceedings began. Ms. A's attorney made his opening remarks, painting a picture of a life devastated by negligence. He spoke of pain, of loss, of a future stolen. It was a compelling narrative, built entirely on the sand of sworn falsehoods. Then it was the defense's turn. Their opening was brief, almost understated. "Your Honor, the claimant's account is compelling. However, we have objective evidence that tells a profoundly different story. We ask the court's permission to play 2 video exhibits." The first video to appear on the screen was the now familiar CCTV receipts from aisle 7. The judge watched intently as Miss A performed her deliberate, controlled descent. A slight frown appeared on his face. This was the staged fall, naked and undeniable in the sterile light of the courtroom. Murmurs rippled through the room, but this was only the preamble. The defense attorney then addressed the court. "Your Honor, the claimant testified under oath that her injury left her unable to lift her young niece, an activity that she described as heartbreakingly beyond her capacity." He paused, letting the weight of the sworn testimony settle. "We would now like to present Exhibit B." The screen shifted to the sunlit park. The same woman who had just claimed an inability to lift a remote control was seen laughing, bending with fluid ease, and hoisting a child onto her shoulders. The contrast was catastrophic. This was the gavel drop moment. It wasn't a sound, but a visible shift in the room's energy. The truth had exploded, silent and devastating. The judge's gaze moved from the screen to Miss A. Her facade had crumbled completely. The performance was over. Her attorney was silent, having no rebuttal to such irrefutable visual evidence. The defense attorney, seizing the moment, simply said, "Gavel down." It was a statement of finality. The evidence had spoken, and no amount of legal argument could refute it. The judge needed no further deliberation. He found the claim to be built on a foundation of fraud and perjury. He dismissed the case with prejudice, meaning it could never be refiled. He further ordered Ms. A to repay the costs of the initial medical evaluations and formally referred the case to the district attorney's office for criminal prosecution for insurance fraud. The courtroom reckonings were complete. Justice was not delivered with a shout, but with the quiet, absolute authority of the truth, presented not in words, but in pixels and timestamps. The gavel did physically fall, a sharp crack that echoed the symbolic one that had already occurred. The case of the grocery aisle limbo was closed, but its implications ripple far beyond that single room. It serves as a stark lesson in the power of evidence and the consequences of attempting to deceive the system. For the honest payer, it is a small victory, a reassurance that the mechanisms designed to protect them can and do work when confronted with the truth. The journey from claim to conviction reached its terminus, not with a whisper, but with the resounding, satisfying silence that follows the exposure of a lie. This story, Case Code. Grocery Limbo is more than a single case study. It is a microcosm of a silent war being waged against the hereges, quem, ideologicamente, atacamos, those who view the system of mutual trust and protection not as a safeguard, but as a target for exploitation. They operate on the assumption that their word, their fabricated pain, is enough to override reality. They believe the system is too slow, too bureaucratic, or too gullible to uncover their deceit. But this case proves otherwise. It demonstrates that for every staged performance, there is a silent witness. For every fabricated paper trail, there can be a digital one that tells the true story. The emotional twist here is not one of pity for the caught, but of vindication for the vigilant. It's the satisfaction of seeing a puzzle solved not by a brilliant deduction, but by the patient, methodical collection of facts. The real protagonist of this story is not the investigator or the lawyer, but the evidence itself. The CCTV receipts were the star witness. The staged fall was the confession. The verdict reel was the judge and jury. This is a powerful reminder that in the end, the truth has a way of asserting itself, often in the most mundane of places. A grocery aisle, a public park. So, what is the provocation? It is a challenge to our own skepticism. It asks us to demand proof before hype. It encourages us to look past the emotional appeal and seek the objective facts. This case is a weapon in the hands of the honest payer, a blueprint for how these deceptions are dismantled. It shows that the system can fight back, and it wins not with rhetoric, but with receipts. Let this be a warning to those who would consider a similar path. Your performance is being recorded, and one day, a judge will press play. This is how a lie unravels. If you stand for truth over fraud, stand with us. Protect the system. Be the honest payer.